Can you petition for your stepchild's immigration? Have you ever wondered if you can help your stepchild immigrate to the United States? Many families face this question, and today we will break down the steps involved in petitioning for your stepchild's immigration. Yes, you can petition for your stepchild's immigration by filing Form I-130, which is the petition for alien relative, with the United States Citizenship and Immigration Services. This process allows a U.S. citizen or lawful permanent resident, also known as a green card holder, to sponsor their stepchild for lawful permanent residency, commonly referred to as a green card. To start, there are some key requirements you need to keep in mind. First, you must be legally married to the child's biological parent. This marriage should have taken place before the stepchild turned 18 years old for the petition to be valid. If the marriage occurred after the child turned 18, you generally cannot petition for them as a stepchild. Next, the age of the stepchild is important. The stepchild must be under 18 years old at the time you married their biological parent. If they were over 18 when the marriage happened, the petition may not be possible. Once you have confirmed these requirements, you will need to file Form I-130 with the United States Citizenship and Immigration Services. This form requires you to provide proof of your relationship, such as marriage certificates, birth certificates, and evidence showing the relationship between you and your stepchild. After the petition is approved, the next step depends on where the stepchild is located. If they are already in the United States, they can apply to adjust their status to become a permanent resident. If they are outside the United States, the case will proceed through the National Visa Center and the U.S. Embassy or consulate in their home country. It's also worth noting that you do not need to adopt your stepchild to petition for their immigration. Even if the stepchild is adopted, you still must file Form I-130 to start the immigration process. For stepchildren under 21 years old who are unmarried, they are considered immediate relatives if you are a U.S. citizen. This means they do not have to wait for a visa number to become available, which can speed up the process significantly. Keep in mind that processing times can vary. The petition process may take several months to over a year, depending on your status as a citizen or permanent resident, the location of the stepchild, and the processing times of the United States Citizenship and Immigration Services. For Latino families, understanding these requirements is essential to successfully petition for your stepchildren. Make sure to gather all necessary documents carefully, respond promptly to any requests from the United States Citizenship and Immigration Services, and consider consulting with an immigration attorney to help you navigate the process smoothly. Remember, ensuring that your marriage to the biological parent occurred before the child turned 18 is a critical factor that can affect eligibility. This petition process provides a legal pathway for Latino stepparents who are U.S. citizens or permanent residents to bring their stepchildren to live permanently in the United States.